You hear horror stories about people dying without a will and the impact it can have on a family left behind. The good news is those stories rarely happen. WSBT-22's Bob Montgomery looked into this for us, and he found there are myths and realities when it comes to how things are handled after your life ends.
One big myth is you have to have a will or most of what you want to leave to your family ends up in the hands of the government and your children become wards of the state. Well, that rarely, if ever, happens, says John Ford, an estate attorney with Jones Obenchain in South Bend. He's a director with the Michiana Estate Planning Council. Ford says wills are important because they're the best way to make sure the people you want handling your affairs will and your property goes where you want it. That's especially true in some pretty common circumstances.
If we have a second or third marriage and children from a first marriage, that's a situation where there absolutely needs to be a will. If there is a desire to take care of grandchildren or someone beyond a spouse and children, that's a situation that demands a will.
Or when a business ownership or partnership is involved. A will, it turns out, can be handwritten or bought off the internet as long as it's signed by two people not listed as a beneficiary. Now, Ford says the biggest problem is those do-it-yourself approaches often leave out critical information.
I think the problem is that you don't know whether it fits your situation or not. And so the concern isn't necessarily that what you're doing is invalid. It's probably valid. The concern is, does it do everything it needs to do? Does it leave anything out?
He always said, is a losing argument. It really is going to come down to what's in writing. And if there's nothing in writing, then it's going to come down to what is the intestate distribution.
Which means distribution without a will. Attorney Paul Crowley of Butler and Crowley in South Bend says that's where probate court can come in. Both attorneys say probate court can get a bad rap, but it actually works to guarantee your estate is distributed fairly, even if there's not a will. Crowley says, though, everyone should have a power of attorney and a living will. He uses his own example of when his daughter turned 18 and became a legal adult.
Because she goes off to college and she gets in an accident and she's in a hospital. And there are HIPAA rules that prevent the hospital from talking to anybody about their patients unless the person has authority. My daughter doesn't sign that power of attorney. We have no ability to care for her.
Two types of powers of attorney. One is for healthcare, the other one is for your financial life. A living will usually takes that painful decision out of the hands of a family member on whether to pull the plug on your life.
A lot of people worry about estate taxes as well.
Yeah, it really is not an issue so much in Indiana and Michigan because there are no estate taxes in Indiana and Michigan. Federal government does kick in about $5 million. For the average person, that's not really a consideration. Your estate isn't going to be up to that $5 million mark. However, you can avoid that. If you are in that scenario, you can set up a trust. But some of these trusts can be a revocable trust. In fact, it's a great thing, but it's a pay me now or pay me later scenario. It's expensive to set up on the front end.
Yeah, I mean, the bottom line with all of this, there's really no good substitute for having a professional look at all of this.
Yeah, both attorneys said the same thing. They said a 30-minute Google search is not going to equate of 3 years of law school and 30 years of estate planning experience when they set up these plans.
As you said in the story, when they said, he always said, well, you don't have it on paper.
That's right.
There you go.
It's not a winning argument.
Yeah, Bob, thanks very much.